Yield back. Thank you.
May we now look to the gentleman from New York, Mr. Grimm.
Thank you, Chairman. And thank you, Chairman. You've been very gracious with your time. Trying to bring a little continuity, we were just speaking about the Jobs Act. One of the provisions of the Jobs Act, I believe, brings shareholder limits from 500 to 2,000. Just for clarification, is that going to be implemented? Is that effective immediately, or is that after all the rulemaking with the rest of the Jobs Act is done?
I believe this requires some rulemaking. But I don't think it's, I'm sorry, I'm not recalling right now. I don't think it's very much rulemaking in this regard, unlike crowdfunding, which requires much more extensive rulemaking.
I'll take that as after the rulemaking, it'll become effective.
You
want to get back to me on that one?
Yeah, I'd like to get back to you because, in fact, we've had one bank already come in to deregister, and we obviously haven't done rulemaking, so it may be that it is immediately effective.
Okay.
I'm just not remembering exactly.
That's fine. In that same vein, my understanding is that it was drafted in a way that it may not include savings and loans. But my understanding is you have the authority within your purview to fix that. Can you or will you fix that?
We are looking at that. I received a letter about a week ago from a number of savings and loans asking us specifically about that issue. So the staff is looking at that.
Okay, great. Switch to Volcker for a second. As written, the Volcker rule proposal could treat a mutual fund as a banking entity in limited cases. For example, I think a bank sponsor that's just launched a mutual fund and owns nearly all the shares of the new fund. As a result, the mutual fund itself would have to comply with trading and investment restrictions of the Volcker rule. Yet that fund, like all mutual funds, will eventually become wholly shareholder-owned. The proposed rule also states that a banking entity is prohibited from having an ownership interest in or acting as a sponsor to a hedge fund, private equity fund, or similar fund as the agency determines collectively. The proposed rule calls it a covered fund. That term is defined so broadly that it could sweep in a range of investment vehicles, even highly regulated mutual funds. So my question is this. Do you agree that the Volcker rule should not limit a bank's ability to sponsor or invest in registered investment companies?
Well, I will say that these are issues that have been raised in the course of the Volcker rulemaking. We've gotten 18,000 comment letters, and it is a joint rulemaking among all the financial regulators, and that is one that we're looking at very closely. The prohibitions and the extent to which we have any flexibility with respect to sponsoring funds. I don't have an answer right now.
All right. I'll broaden that. Congress's intent, I don't think, was restricting a mutual fund's trading and investment activities.
I think that's probably right.
Okay. Fair enough. If we could go back for a second, you mentioned before, my colleague asked about MF Global, and you threw out some stats. I think it was 318 securities accounts as opposed to the vast majority being CFTC segregated customer funds.
Right. I believe there are 36,000 futures accounts and only 318 active securities accounts.
Okay. That's what's bothering me. That begs the question. When the SEC staff recommended going with SIPC, Chapter 11, when you look at the disproportionate number of accounts, this firm mostly was covered by the CFTC. The vast majority was covered by the CFTC, which would make me lead that the suggestion should have been to let the CFTC have the bankruptcy under Chapter 7.
Well, the SIPC handles the bankruptcy of the combined entity, which was a broker-dealer as well as an FCM.
Actually, my understanding is that the law says that they have the ability to do so. It's discretionary, which is why you had the conversation in the first place. You wouldn't have needed a recommendation if the law said it has to go into SIPC.
I don't recall that there was any discussion about, and I could be wrong, and I certainly wasn't in on every conversation, about whether or not to somehow try to separate the broker-dealer piece of this from the FCM piece of it. And of course, the trustee is working mostly to try to.
No, but here's the problem, Chairwoman. Here's the problem. Now that it's gone Chapter 11, the segregated fund, the customers, have become creditors. They were never creditors. Had it been under Chapter 7, they would have been protected, because now they're going to be in UK foreign courts, which you've seen with Bear Stearns, you've seen with Lehman Brothers, years and years of litigation. But if you're a creditor, that's fine, you've taken on that risk. But as someone that has the protection of a segregated account, and that goes back to your statement before, that your part of your mandate is ensuring the integrity and consumer confidence of the markets. If I'm a foreign investor and I'm putting my money in an FCM, I'm told that that money cannot be touched. It is protected. Guess what? The decision that the SEC and CFTC made just turned that upside down, because that's not true anymore. Because the monies that were taken out of those segregated funds, unlawfully, however it was done, shouldn't have been done. We understand it shouldn't have been done, but we know it does happen. That's why we have criminal statutes in place, but it does happen. People break the law. The bankruptcy decision took away my rights as a customer and made me a creditor. Why would I ever invest in the U.S. markets again under those circumstances if regulators can decide by bankruptcy law, well, now you're a creditor? And that's why I think that in light of Bear Stearns, in light of Lehman Brothers, we should really be looking at that, because those decisions matter, especially when it's 318 securities accounts, which means they really weren't doing much securities business, over 36,000 customer accounts. They were mostly in FCM, and therefore the CFTC should have put it under Chapter 7, in my opinion.
And the
I thank you, and I yield back.
gentleman yields back. Gentlelady from New York is recognized.